Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, on 30th of September 2023, the Honorable Supreme Court has pronounced one judgment. It's a reportable judgment. It's Criminal Appeal number 2069 of 2072 of 2022, and it's Appellant versus the state of Sikkim. This is a case title, and in this judgment, the Honorable Supreme Court has acquitted the appellant accused, who was convicted by the Honorable High Court, and the Honorable High Court has reversed the judgment and has interfered in the order of the acquittal. Let's see the contents of the judgment and try to learn the contents of the legal principles which the Honorable Supreme Court has made out. This is the appeal which will question the legality and the validity of the judgment and conviction. And so this paragraph states about the appellant has challenged the order of the High Court of the Sikkim at Gangtok in the criminal appeal number so and so, in which the High Court has reversed the order of acquittal and convicted the appellant accused under the provisions of Indian Penal Code under section 302, that's defined the punishment for the murder, and has directed to undergo a simple imprisonment for the life. And the prosecution case was that the appellant accused has committed the murder of his grandfather, and FIR, first information report, was lodged by the prosecution witness, who was the daughter of the deceased, and she has informed the police that her deceased father, who was 81 years of age and was found to be who was living with her and murdered, and he was murdered with a sharp-edged weapon. And the investigation was completed and Chargesheet was submitted against the appellant accused, and he was charged under section 302 of Indian Penal Code, and the total of number of 117 witnesses were examined and was appeared on the behalf from the side of the prosecution. And before the trial was commenced, the appellant accused has raised the plea of the insanity, and he was referred to a hospital at Gangtok, where he was examined for his mental state by the consultant neuropsychiatrist. So, and the court has also made an observation that this ground of insanity was not pleaded from the side of the appellant accused when his statements was recorded under section 313 of the Code of Criminal Procedure. 313 is a statement where accused was granted an opportunity to make their statement but without oath, and the court asked why the incriminating evidences were against you, but he has not raised this plea of insanity, but has made a statement that he was ignored about the occurrence of the incident at the time when he and has denied that he has ever attacked his grandfather, and that after the completion of the evidences, the trial court has examined the matter and within the ambient of section 84 of the Indian Penal Code. This section 84 is an exceptions of it defines that nothing is a crime which is committed under the act of the insanity. So the learned trial court has examined the case under section 84, and it finally concluded that the accused was not in a position to deny the nature of the offense because of his unsoundness of the minds, and it is highly probable that he was unaware about the incident what he was doing, or which is contrary to the law. And the trial court has acquitted the accused and agreed from the acquittal order. The state has filed an appeal before the Honorable High Court of Sikkim at Gangtok, and where the Honorable High Court has reversed the order of the trial court. And then finally the appellant accused got convicted, and then he files an appeal before this Honorable Supreme Court of India, and the counsel appeared and they made their submissions. The court, after hearing the counsels at length and made their observations and discussed the evidences, and as far as the prosecution witnesses was concerned, which was laid down before the Honorable Trial Court as well as the High Court. So, and they says that PW1, who was the daughter of the deceased, and she lost an FIR and has deposed that the deceased used to stay at her house, and deceased has gone to the Dishara to celebrate Dishara at the house of her elder sister, but returned to her house on so and so date with the appellant accused. At the morning, she heard some water stream of the washing of the. She has gone to nearby water stream for washing the household utensils, and someone saying some words and in the local language, aya, and heard some strange sound. That when she rushed to her house and she saw that appellant accused has holding the weapon and he was aiming towards the deceased, and she snatched the weapon from the accused, but saw that the deceased, the deceased means her father, was lying on the bed, and she also saw that accused has been trying to take out the windpipe from the neck of the deceased, which has already been cut. She separated the appellant accused from the deceased, and another prosecution witness, PW13, she had arrived at the place of the occurrence of the PW1 scream. When she reached the house, she saw the appellant accused pulling the deceased by her neck, and the prosecution witness is the doctor who examined the deceased. So he has made his observation, which is medically related, and now the court has discussed the issue of the insanity. And prosecution witness 2, during her cross-examination, has admitted that the appellant accused was studying at the Dehradun, and he was brought to the Sikkim as he was suffering from the mental illness. This was the portion which the Honorable Supreme Court has noticed, that he has brought back to the Sikkim as he was suffering from the mental illness, and PW1 was also admitted that, but she was not aware whether the accused has been suffering from the mental illness or not. And in the year 2015, and DW1 who is the mother of the accused, and she also made a statement that in the year 2015, one of his friends, means the accused friend, has telephoned that accused has fallen ill and he was fighting with his friend, and he was brought to the Sikkim, and he was taken to some spiritual healers for treatment, but no relief, no avail, but to no avail, means he was not benefited by the treatment given by the spiritual leaders. Sorry, the spiritual healers, not leaders, healers. And the appellant accused, the doctor who has conducted the examination of the accused, as per the opinion, the appellant accused seems to have major depressive disorder with psychotic features and has partially impaired judgment due to the perceptive. We was found to have a partially impaired judgment due to the perceptive auditory hallucinations. This was the examination which the doctor, after who has examined the appellant accused for his mental state. So, after examination, after analysis of the evidences, the court has analyzed the section 84 of Indian Penal Code, which says that act of the persons of the unsound mind, which says nothing is an offense if it is done by a person who at the time of doing by reason of unsoundness of mind is incapable of knowing the nature of the act or what that he is doing what is wrong or contrary to the law. This is the 84 of the Indian Penal Code. And some judgments was quoted by this Honorable Supreme Court. And in the one case, Surendra Mishra versus State of Jharkhand, and Hari Singh Khan versus State of MP, and Bapu versus State of Rajasthan, and the court has held that who seeks exoneration from the liability of the act under Section 84 of Indian Penal Code has to prove the legal insanity and not the mental insanity. The court has held there is a difference between the medical insanity as well as the legal insanity. And since insanity or the unsoundness of the mind is not defined in the Indian Penal Code, so it's different. It carries different meanings in different contexts, and this has varying degrees of the mental disorders. A distinction has to be made between the legal insanity and the medical insanity. And the court is concerned with the legal insanity and not with the medical insanity. The court, after these judgments were discussed and the court has held, there is a difference between the legal insanity and the medical insanity, and the accused who wants to be exonerated, who wants to be acquitted, he has to prove that he was suffering from legal insanity and not the mental. Medical court has nothing to do with the medical insanity. And the court also held that there is no difference there, that the meaning has not been defined, insanity has not been defined in the code, in the penal code. So another judgment was there, and this judgment in and there's a one judgment, and it's well settled principle. If the trial court has acquitted the appellant accused, and the High Court at very rare case should interfere with the order of acquittal unless the trial court order has been suffering from perversity or some lack of reasonableness is there, or merely some another view was possible, the appellate court should not interfere with that order. So the appellate court should not disturb the findings of the acquittal order merely because another view was possible. This has been discussed in the state of Rajasthan versus Abdul Manan. This was a judgment. It's a well settled principle. At very rare cases, the court should have to be interfered with the order. So now, after making all these discussions, the court finally held the High Court has reversed the order of the acquittal and convicted the appellant accused merely on the reappreciation of the evidences, by holding that trial court has erred in the extending the benefit of Section 84 of Indian Penal Code without even recording finding that trial court finding is perverse. So it means even if the High Court wants to interfere with the order of acquittal, the court must have to make this kind of recording that the trial court order is suffering from perversity. This has not been recorded by the trial court, by the High Court. So Supreme Court find it's a fit case to interfere with the order of acquittal, interfere with the order of the Honorable High Court. So the Honorable Supreme Court has reversed the order of the High Court and set aside the judgment of the High Court and restored the order of the trial court. And as a result, the accused finally got acquitted from all the charges. This was a judgment which came on 13th of September 2023. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.